Hey guys, welcome to another episode of The Critical Jurist. Today we're taking a look at a case where a cop gave his badge, his gun holster, and his handcuffs to his drug dealer who then used it to commit a crime. He was found guilty of this crime and we're reviewing his opinion. Now, the question in this case, the specific question we're looking at today is whether, and follow closely because this can be a brain teaser. The key question is, can a reasonable party look at the same facts and come up with reasonable doubt when another reasonable party looked at the same facts and had no reasonable doubt? Is that possible? The significance or the importance of this question is to the rationale that the court gave for deciding that the man was guilty, or at least refusing to review the decision that the jury made. So let's go through the facts. Now, this guy is a cop in the Massachusetts Police Department, or Boston Police Department, Dedham Police Department. And he is addicted to Percocet. So he has a drug dealer that he goes to once, twice, or three times a week to buy Percocet from. This drug dealer suddenly starts asking him for information. So if the drug dealer is involved in a road rage incident, he comes back, picks up the phone, calls the officer, and is like, I need you to provide me the DMV, or in Massachusetts, the RMV records of this person, license number this. Look through and provide me the RMV records. Now, the RMV records will have the person's name, his face. They will also likely have the person's address. So giving this information to a drug dealer who has already shown he's prone to violence is in of itself a very stupid thing to do. Or at the very least, not wise. This cop, however, provides this information to him over time. Now, there's no evidence that anything ever came of it, so there's no evidence that the man used this information to go after those people and try to harm them. So we're not going to make any assumptions there. But giving the information to him in the first place is not very smart because it opens the door for those kind of things to happen. Now, this goes on for a while. I think he was buying drugs from him for about 18 months, a year and a half. And then one day he asks this guy for not just the RMV records of some other dude, but he also asks him for the BOP records. That's the Board of Probation records of this individual. Behind the scenes, what was going on was he was involved in a love triangle between him, some other lady, and some other dude. And there was tension between all three of them over time. The lady was sleeping with this guy, and she was also sleeping with the other guy. And so tension began to come up. At some point, the second man, not the drug dealer now, the other guy, came over to the drug dealer's house and tried to vandalize his car. And there was a car parked in front of the guy's house, and instead of vandalizing the guy's own car, he thought it was his car. So he just vandalized the car parked in front of this guy's house. Now, that car did not belong to him, but that was irrelevant to the facts. So this third guy gets arrested. He goes to prison for a couple of months, and he comes out. When he comes out, this guy then asks the cop, the drug dealer asks the cop, to give him the Board of Probation documents, files for this other dude. Now, the cop did. He provided both the RMV records and the BOP records for this third party. Now, this in of itself is dumb, but looking at the fact that he's provided it in the past and maybe nothing happened, there's no evidence in the opinion that anything happened. He provided those records. Now, where he should have gotten suspicious is where the guy then asks him afterwards. I'm not sure it was in the same sitting, but maybe sometime after, asked him for his gun, his gun holster, his badge, and his gun holster, his badge, and his handcuffs. He provides those items to him. He provides those items, not just one badge, he provides him 4 badges. So now the guy can give these badges to other people. Now, off the bat, this seems like a dumb idea. His defense was that he gave it to this other dude because, number one, he didn't think the guy would use it for anything, at least not as illegal as kidnapping or killing someone. That's one. Number two, he just didn't ask too many questions. He gave it because he wanted to keep access to getting his drugs. So don't do drugs, kids. That's one of the lessons here. Don't do drugs. This other dude takes all these items. Again, the cop asks him, what do you need it for? He says, I just need it. Don't worry about it. It's not a big deal. And he didn't push any further. He gives this guy his items. This guy takes these items. He dresses up as he doesn't dress up as a cop. He calls two of his friends. And these two friends then dress up as cops. The plan was they'd go over to this third party's house, dressed up as cops. They'll knock on his door and tell him, "Look, we're from the police constabulary, and which is basically the police force, and we want to take you for an impromptu drug test," which they do, and they then bring him to his house. The plan goes accordingly. He gives two of his friends the police uniform. He gives them the badges, the handcuff, the gun holster. They go to this guy's house and they knock on the door. He's living with his parents at the time. The guy agrees to go with them, even though the parents are a bit suspicious. They're like, "How are you sure these guys are from the police?" And he's like, "Well, they have badges, they have guns, the 9 yards." And so he agrees to go with them. They handcuff him, put him at the back of a car. Now, I'm not sure this is regular police procedure, but if there are any criminal lawyers watching this, let me know if regular police procedure when you're taking someone for a drug test is that you handcuff them. I could see how that could make sense, because if the person maybe is on drugs actually, then they may become violent. It may be a tense situation for them. But it doesn't seem like something that you do just regularly. But let me know in the comment section. Anyway, so these guys take this guy. They put him at the back of the car. They drive him over to the drug dealer's house. They park outside the house, bring this guy out, and put him in the garage. Now, they then strap him to a chair. I'm sure at this point he gets suspicious, which he should have. Now, this other dude, and by the way, just add to the facts, this drug dealer uses a wheelchair. Now, I'm not sure that he always uses the wheelchair or just sometimes, but it was there in the fact that he uses a wheelchair. The cop stated that he gave this guy his items because he didn't think there's much this guy would have been able to do with it, right? But when you're giving somebody 2, 3, 4 badges, then you'd think even if he's not going to use it, he'll probably give it to somebody else to use illegally. He gives this guy, they bring this third party to the house, they strap him into a chair, and they leave. We don't see any more details about what happened in the crime, but what we do know is like 4 or 5 hours later, he calls these other 2 guys who had helped him bring this guy and tells them to help him dispose of the body. So they drive the body out to the woods and they bury him. He was dead. Now, interestingly enough, in this case, what I thought they charged the cop with is accessory to murder, but it looks like there may not have been enough facts to link him to the murder, because it requires specific intent, right? If you're an accessory to a murder, you would know about the murder. It's not just you are reckless, but you had knowledge. What they charged him was accessory to kidnapping. And their argument was the requirements for accessory to kidnapping, and this is where the law has very clear linings. The requirement is that he had knowledge. He had double knowledge. He had knowledge that there was a crime that was about to take place, and based on that knowledge, had intent that the crime would actually take place. Now, his argument is that the evidence doesn't show, number one, that I knew that the crime itself was going to take place, but even more so, the evidence doesn't show that I intended for it to take place. Now, after this other dude went missing for a while, they didn't find him for a year. The third party wasn't found for about a year. And after there was a missing persons report filed, and they had put up all the posters around so that anyone who knew this guy could report anything in, right? They also put these in police stations as well. And he saw one of those posters and he called this dude and he's like, "Dude, do you know anything about the disappearance of this guy? Because I know you guys had beef." And he said, no, he doesn't know anything about it. He denied it. And the denial didn't make sense to him per the court records, but he didn't push any further because he didn't want to upset the drug dealer. And there's also evidence that when they called him, when the people investigating the murder called him out and said, hey, we have questions relating to this guy who we just arrested, which was the drug dealer. And he actually said, is he related to this missing person? Which, let's take a break here. Now, regularly, the innocent would always go scot-free in a court case, right? But I just want to tell everybody watching this out there that the system isn't well designed enough to make sure that innocent people go scot-free. So even if you're innocent, this guy was guilty at least of something. But even if you're innocent, do not ever talk to the cops freely. Don't. Have a lawyer there. Because if you're innocent, the lawyer will tell you, okay, say this much and let it stop there. Say this much and let it stop there. Know that the system is not perfect because humans are not perfect. People will make assumptions. They'll have leaps of logic and ignore certain things where it is in their incentive to do so and where they have the power to do it. So even if you're innocent, never ever speak to the cops without an attorney. Never. Even if you're innocent, even if you think it to make you look guilty, lawyer up and talk with a lawyer, because then they'll help you see when you can come to a good deal, no matter what, right? Better safe than sorry. But he decides to talk to the cops because he doesn't think he had anything to do with the murder itself, right? So he talks to the cops and he's like, is he related to this guy? And they're like, yeah, how did you know? And he tells them what he knew. Then he gets arrested and where we are. But so his argument to his appeal, which we're looking at today, was that, look, the evidence, so the jury can make a decision, but they need to make the decision based on the evidence. The evidence that we have does not show that I knew, the elements of the crime require that I knew that a crime would occur and that I intended for it to occur. There isn't even enough evidence to show that I knew that a crime would occur, right? Not reckless, because you give somebody your gun and you give somebody your badge and you ignore asking them why. Do you know a crime is going to be committed, or are you just reckless towards it, right? Are you being reckless? Okay, something may happen here, but I'm not going to look at it. Now, so his argument was that there's no evidence that I knew, and even if there is, there's no evidence that I intended for the crime to actually occur, especially the kidnapping. Now, not the murder, but the kidnapping of somebody, the kidnapping itself. I did not know there would be a kidnapping, and I did not know that, and I had no intent for the kidnapping to take place. You could make the argument that if he knew at that specific point that there was beef between this guy and this guy, he provided the BOP records, he provided the RMV records, you could make the argument that then you would have an inclination, if you can connect these two together, right? You'll have an inclination that, okay, if he's collecting this information for this guy, then he's going to use these other things in a way to do something. You might not know specifically what, but you know it's going to be illegal and it's going to be harmful. So you have the requisite knowledge. That argument can be made. Now, you could also make the counter argument, which is not a very strong argument, that I knew he may use it for something, but there are other uses, which he argued in court, and I wasn't listening to the opinion, so I can tell you how convincing it is. There are other ways he could have used this information, these items that I provided to him, and if he did not have the connection, so if the request for these items did not come in the context of them talking about this third party and what he had done to him, and now he hated the guy for stealing his girlfriend, then there's no way I would think, just from you asking for those things in a different context, that you're asking to use it to harm this guy, right? So you could make that argument. So that's the crack in the law that he's trying to use to get out. Now, I think overall, the court didn't have much of a choice. The decision they came to is a decision that anybody, including I, would have come to, especially the fact that it goes beyond reckless when you give somebody such powerful items, your gun holster, 4 badges, not 1, not 2, 4 different badges, and you give your handcuffs to this guy, right? Then that goes beyond reckless. You know this guy is going to use it for a crime. You may not know what specific crime, but you know he's going to use it for a crime, and you don't care enough to stop him or to question him, right? So then you become more of an accessory. So I think the court made a good decision. Now, the question though is how the court reasoned to get to that decision. The court's reasoning was that, and let me read this. The court's reasoning and this is a brain teaser. So here's what it says, and I'm reading from my blog post on this, not from the court opinion, but I'll do this for where the court starts speaking. The question, the court says, is not whether everyone would view the evidence as being sufficient. So a rational person anywhere else may or may not view the evidence as sufficient to convict this dude, right? The question is whether any rational trier of fact could have found the essential elements, so now I'm quoting the court, could have found the essential elements of the crime beyond a reasonable doubt. Beyond a reasonable doubt. Any rational person could have found the essential elements of the crime beyond a reasonable doubt. The court went on to explain that the relevant question is whether the evidence would permit a jury, any jury, to find guilt beyond a reasonable doubt, not whether the evidence requires such finding. Now, the brain teaser here is, if one rational person would look at a set of facts and be convinced beyond a reasonable doubt, not just convinced now, but convinced to the point where I have no doubt this guy did it, right? Would another trier of fact, rational, because this is used in the court's opinion, would another rational trier of fact not look at the same facts and come up with the same verdict beyond a reasonable doubt? Is that qualifier beyond a reasonable doubt that raises all the questions? If a rational person looks at something and beyond any doubt is convinced that this guy did it, wouldn't another rational person look at the same facts and come up to the same conclusion? Again, rational and beyond a reasonable doubt, not just any doubt, because you can have some doubts. Okay, maybe this guy did not know, but is it a reasonable doubt, right? And now this is the standard used by the court in other cases, not just in this case. And so the court says, look, that we looked at the evidence and we can see a scenario, basically a scenario where a jury would have looked at this and been convinced beyond a reasonable doubt. Whether or not we are convinced beyond a reasonable doubt is an irrelevant question. Would a jury be convinced beyond a reasonable doubt? And the court says they could see a scenario where a jury could be. The evidence is sufficient such that a jury could look at that and come beyond a reasonable doubt. Now, don't forget there is more than one juror. There are 12 jurors. So if you convince 12 people who are supposed to be rational beyond a reasonable doubt, so meaning not even one, because if one person says no, then the whole thing falls apart. But meaning not even one person was not convinced, not even one rational person in a group of 12 was not convinced that the evidence was insufficient. So then wouldn't any other person that looks at this, any other rational person be convinced the same? Now this test realistically is an out. The test is a statement from the court saying, beyond clear evidence of abuse of discretion, beyond any evidence that the jury behaved irrationally, we're just not gonna second guess them. Which, if you look at the separation of duties in court, the judge is the trier of law. Their duty is to make sure that the law is followed. And the jury is the trier of fact. They listen to all the witnesses and they judge them and judge their credibility. So the real test here is not really whether any rational person. I think if a group of 12 rational people sit, and that's a big assumption, because realistically there will always be one or two who are not being rational, or even more, depending on how the jury selection process goes. If there are 12 rational people, and all 12 rational people come to the same conclusion, then chances are, if any other rational person, again, they come to the same conclusion beyond a reasonable doubt, then any rational person would look and come to the same decision. But that's theoretical. It's theoretical because in a jury of 12, you'll never have 12 rational people. It's theoretical because there will be other factors that will come in, emotional factors, social factors, cultural factors that will come into play as to what a rational person would even do in the first place, but also that would bring a lot of irrationality into the case. That's why you can have one juror holding off, but the other 11 will convince the juror otherwise for one reason or the other, including just we've been here for too long, we want to go home. So there are many different factors. So really the test is not whether any rational person, the court uses the word rational because we need to have a certain expectation of the legal system. But the test here is really, is there a scenario where any jury would convict this guy based on the evidence? But even more so than that, I think the question is there a clear abuse of the discretion of the jury? Is this just so ridiculous that no rational person would look at that? So I think it's a negative test. No rational person would look at this and not convict based on the facts. Then the court will probably step in and say, yeah, if no rational person, if the facts are so different from the conclusion that no rational person would have reached that conclusion, then we'll step in. But if there is any likelihood that a rational person will look at this and come to a different conclusion, then we just won't get involved because of how the court structure, the court system is structured to allow the jury handle the facts and the judge handle the law. So let me know what you think in the comment section. As for this guy, the court affirmed his conviction and he'll be going to jail for a little while. I think like 8 years for accessory for kidnapping. That's the ending of that case. Let me know what you think in the comment section. I'll see you guys in the next one.